Well, fantastic, and once again, thanks to everybody for attending the whole regular Human Services Background Study Eligibility Task Force. We're here on the 14th of January, and we have a lot of people here. And I just want to maybe we'll just start and get this out of the way that we are going to do a formal roll call today. So, Mr. Vogel, would you please move forward with that?
Certainly, Mr. Chair. Senator Champion.
Here.
Thank you. Ms. Dawson.
Present.
Mr. Esme.
Present.
Ms. Vice Chair Evans.
Present.
Chair Griffin.
Present.
Mr. Hanson.
Present.
Mr. Urban. Mr. Urban. Ms. Kaser.
Present.
Ms. Case. Thank you. Professor Kammer.
Present.
Lieutenant Knotts. Lieutenant Knotts. Judge Kulik.
Here.
Senator Matthews.
Present.
Ms. Mattson.
Here.
Representative Moeller.
Present.
Inspector General Modi.
Present.
Mr. Page. Mr. Page. Ms. Robertus. Ms. Robertus. Representative Robbins.
Present.
Mr. Sandoval. Mr. Sandoval. Judge Satterback. Judge Satterback. Ms. Sherlock. Ms. Sherlock. Mr. Tatum. Mr. Tatum.
Present.
I'm glad to see that you're able to attend, Mr. Tatum. Ms. Williamson. Ms. Williamson. All right, Mr. Chair, 15 members of 23 are present. A quorum is present.
Thank you, Mr. Vogel. I appreciate that. And I think the first thing I want to do today is acknowledge a new member to the task force. We now have Professor Roy Kammer. And Mr. Kammer, could you just introduce yourself briefly and welcome?
Thank you. My name is Roy Kammer. I'm a professor at Minnesota State University in our Alcohol and Drug Studies program. I am here as a member of the Board of Behavioral Health and Therapy. I have practiced as an alcohol and drug counselor. I worked for the Hazel and Betty Ford Foundation for a number of years and practiced at the University of South Dakota for a number of years prior to that, and a lot of background in counselor education. So that's me, and I'm so happy to be here. Thank you.
We're happy to have you, so thank you. And why don't we then, I want to sort of address an issue that we have a really full calendar and agenda today. So I've asked Mr. Vogel to sort of be the heavy today and keep us all on task and target. He'll sort of play the walk-off music or interrupt you at some point if you're talking. So we're just trying to make sure we hear everybody's voice today. So thank you, Mr. Vogel, for assuming that duty. Copies of the December 10th meeting minutes were posted on the task force website. And I just want to open up briefly to see if anybody has any corrections, additions, any concerns with the meeting minutes posted on the website. Okay, and I don't see any hands up or any objections. So at this point, we will approve the meeting minutes as they were distributed. Thank you. Today, our goal, and I don't know if everyone has reviewed the agenda, we're going to do a few things. We're going to hear from subcommittee members. on the work that each of them are doing. In the subcommittees, we're going to have a general discussion about a prior task force that looked at the disqualification laws, and we're going to open up a discussion to how we can best incorporate people with lived experiences in this process. And this might be a little bit of a bummer for some people in the disqualification subcommittee, but we're going to spend a little bit of time going over the 2007-2008 task force recommendations. I apologize to the disqualification subcommittee because we kind of did this, but I think it's important. If there are two documents, one of them is a 54-page document, the others is over 70 pages, and I know that people are busy, and this will serve as just an overview of those recommendations. And the idea is we don't need to recreate some of this. We had smart, intelligent people work hard on this before, but we are looking at this as more of a beginning than an end. And these are just some of the recommendations that were gone over. Mr. Vogel, do I have authority to share a screen? Do you know?
Mr. Chair, I believe you do, but I'll check the settings just now.
It's working. But that's not what I wanted to do. Well,
And Mr. Chair, I do have a copy of that report up on my screen if you'd like me to share it on my end.
you know, I'm just doing I did a quick PowerPoint, and I'll just do it that way. Can people see this? See the slides? Okay. You know, this is not designed to be all that fancy, obviously, but it is something I do want to share. So, all right. So this is just going to be a short overview of the 2008 task force report. So that the task force was in 2007, but I think the date of the report was 2008. It was a broader view, as I understood it. It looked at the collateral sanctions and consequences of having a criminal record in Minnesota. So what I'm extracting from this is just some of the DHS and the background study information. So the overview, the legislature created a task force somewhat similar to the work that we're doing. It was in part looking at disqualification laws, and the task force issued a report of its findings, and it included recommendations. There are really several, I think, recommendations that are consistent with the work that we're doing, and I'll go over these in some significant detail in a minute. But one of them is to reconsider disqualifications for drug or alcohol-related offenses and clarify the policy. Eliminate all permanent bars, other than those for murder, manslaughter, and criminal sexual conduct. And as we've talked about before, there are these certain level of crimes or matters that permanently prevent you from working in these direct contact positions. The task force chose to eliminate offenses that have no meaningful relationship to the task and responsibilities of the job. The task force sought to reduce the length of disqualifications and create 4 categories. So currently we have permanent, 15, 10-year, and 7-year disqualifications. The task force came up with essentially eliminating most of the permanent bars, have a 15-year, a 10-year, a 5-year, and a 3-year. And we'll go over this, but the idea was that you're really going to separate the crimes against people from property crimes in terms of disqualification. And it sought to overhaul the preponderance of evidence cases. And we're going to use this POE acronym a lot, just because I get tired of writing preponderance of evidence. But just as a reminder, these are the cases where an individual is not convicted of a crime, but the department concludes that based on available evidence, it's more likely than not that they did commit the crime. So no criminal conviction, but still a disqualification. Okay, so a little bit more focused here. The task force thought that it should review the disqualifications for drug and alcohol related offenses and clarify the policy. So in Minnesota, we have pretty much all drug offenses are felonies. So if you have a little bit of meth, like residue, it's a felony. If you have a pound of it, it's a felony. And so under current law, there's not much distinction with the 15-year disqualification period for drugs, that if you have a small amount or if you're involved in some sales. So one of the questions about this is, have you sort of criminalized addiction, and a 15-year disqualification for somebody having issues with drugs doesn't make sense, specifically if they have an extended period of sobriety and are clean for years after. So that was one of the recommendations, and I should say that there have been no changes really to the law based on this recommendation. The task force recommended eliminating the permanent bars other than those for murder, manslaughter, and criminal sexual conduct. It's a little unclear to me if they were saying we need to move those permanent felony convictions and felony matters to the 15-year, or whether or not it would just allow the department to issue a set aside of a permanent disqualification. But the main focus of the recommendation was that people change, and that having a law that provides an absolute bar without looking at any of the facts of the case, any of the facts of the rehabilitation, is unfair. And the task force came up with a broad idea about what's good for Minnesota. And the idea was, it's good for Minnesota to protect vulnerable individuals from people that could harm them. But it's also good for Minnesota if we allow caring, thoughtful people to work in direct care positions, even if they've had some interaction with law enforcement. So that's the balance that the task force came up with. But it really acknowledged that people change, and the department's review or lack of a review, and you just sort of look at the crime 15 years, you look at the crime permanent, didn't make sense, and it didn't allow for rehabilitation and change. And truthfully, some individuals are over policed, some people have different interactions with law enforcement, and it was part of that as well. So the permanent bars need to be significantly changed. Again, this was not changed, and this is still an issue. One of the focuses of the task force was to try to come up with a way to remove disqualifying offenses that don't have any rational relationship between the job. And I just took a few of these here. My apologies, our dog is barking. These are some of the misdemeanor, and maybe these were gross misdemeanor, I don't remember, that they thought should be removed. So wrongfully receiving public assistance, false representation, food stamp fraud, criminal vehicular operation, disorderly house, issuing a dishonored check shouldn't be a 10-year disqualification for an individual seeking to work in direct care. So it sought to look at all of the listed offenses and just remove those that don't seem to have a bearing on whether somebody would be a safe and good provider of direct care services. So going through the list, removing things that don't make sense, and this was part of their list. I encourage everyone to look at it. I didn't want to pull out. So for each of the groups, the 15-year disqualification, the 10-year disqualification, the 7-year disqualification, the prior task force went through each of those groupings and removed those they did not think had a direct correlation to safety. And I just took one of them, but I encourage you to review those, maybe within your subcommittee if it's relevant. The task force really wanted to change the way the disqualification periods ran. So again, we have permanent 15, 10, and 7 now. Essentially what they wanted to come up with was a 4 group of 15, 10, 5, and 3. So the 5 and 3 are new. And part of it, and I wrote that the 3-year and 5-year sort of based on science, and social science literature says generally if people go about 3 to 5 years without a subsequent offense, they're incident of recidivism goes incredibly down. There are a lot of factors in that. There's age, poverty is an issue, but the science supports this analysis. And the main thing that comes out of this, I think, is separating crimes against property as opposed to crimes against people. That if we're talking about safety, it's really the crimes against people. Yes, Representative Robbins, I see your hand up.
Thank you, Mr. Chair. Sorry to interrupt, but I'm really
Please.
interested in that study, and I was just going to ask in the chat if you could send it to us, but the chat is disabled. So if you could send that recidivism study out to the whole group, I would appreciate it.
I will, and there's a bunch of stuff on it, and I will put something together and disseminate it. I think it's a really good idea. Thank you. Representative. So the task force came up with this idea to separate disqualifications, not just on the level of severity, because the way it is now is it's 7 years for misdemeanor, 10 years for gross misdemeanor, 15 years for felony. The task force wanted to break that down a little bit more so that people who commit property crimes, like say you have a felony property crime, you're not serving the same sentence. So you don't have the same disqualification period as somebody that has a felony, let's say assault. And the example I have is under the current law, a third degree felony assault has the same disqualification period, 15 years, as somebody who has a felony wrongfully receiving public assistance. And what the task force recommended was taking felonies against individuals, reduce those to 10 years, and gross misdemeanors against, property offenses at a gross misdemeanor level would go to 5 years. Property offenses that were property offenses that were misdemeanors would go to 3 years. So it would reduce disqualification period based on the science and based on just really the severity that crimes against individuals are more severe than crimes against property. And certainly as we look at safety, they're different. There's a significant discussion about these preponderance of evidence cases or cases where people are disqualified without a conviction. And I know we've talked about this, but I always want everyone to know that the agency that reviews it can disqualify somebody if they have an investigation that concludes it's more likely than not the person committed the offense. So it's a pretty controversial statutory scheme, and the prior task force recommended some significant changes. The task force did not recommend removing preponderance of evidence as a tool for safety of individuals. They found that it was desirable that the state have the ability to disqualify individuals without a conviction to ensure the safety of vulnerable populations. It focused on the idea that there are some individuals who we have a high belief that probably committed a crime that weren't convicted. And that in an effort to make sure we are providing safe care for individuals, that this is a necessary thing to have in place. I'm not saying that we have to adopt that, but that was what the original task force in 2007 came up with. Their requests for—
Can I ask a question?
Of course, please.
It looks like I should have done the raise hand motion. Sorry about that. I'll do that for you next time.
No problem.
Can you just clarify? It's my understanding with the POE, when they talk about preponderance of evidence, that's even if someone was arrested and they were not even charged with a crime. Let's say, for an example, that it could have been determined that it was the wrong person and there were no charges that were brought as a result of it. So there's been no establishment of probable cause, but the department is able to just take facts from a police report or something and then use that as a determining factor as to whether they believe that the person probably more than likely committed the offense. Now, the second thing is, it's also my understanding, you could correct me if I'm wrong, that when they go through that process of the POE process, that there's no adjudication, there's no opportunity to cross-examine, there's nothing that a person gets a chance to present in order to say, it wasn't me, I didn't do it. Can you just clarify if those things are true, because I do think that this is a really controversial and humongous issue. Thank you.
Yes, and I agree 100%. And so the department reviews these preponderance evidence cases all on paper. The department does not interview anybody. So what you normally see in making the determination is the department looking at arrest records, and if they exist, some type of court records, the criminal complaint, and so on. But absolutely, you see preponderance of evidence cases that are decided completely on police reports, arrest reports that aren't even subsequently charged. Either the prosecutor declines to charge based on lack of evidence, or it gets charged and is dismissed without any adjudication of guilt. So you see a pretty wide variety of just some interaction with law enforcement, all the way to the people that are even acquitted. So there's a pretty wide swath there, but absolutely those are situations. And the difficult thing I think that most people have with preponderance of evidence, besides the lack of investigation, is that the individual isn't even spoken to. So you'll get a notice in the mail that says, even though you weren't convicted, based on the preponderance of evidence, we think it's more likely than not you did it, you're disqualified. And then you can request reconsideration of that, which is a paper request. And if you request reconsideration, there's a low likelihood, in my opinion, of success on reconsideration. Just doesn't happen very often unless you can, unless you got a video or something. And so then after reconsideration is concluded, you get a fair hearing under the Department of Human Services fair hearing rules, which is an administrative hearing. You can, within a fair hearing, you could subpoena people to cross-examine, but usually it's going to be based on those the court records and the police records. It's a bit of a frightening system. And of course, since it's not a criminal matter, you have no right to representation. The Department of Human Services will be represented almost always by someone from the Minnesota Attorney General's office. But if you are determined to have committed based on preponderance of evidence, you don't get an attorney, and it can be a very difficult process because it is questioning, cross-examination, witnesses, exhibits. You really to have success, you need an attorney.
Excuse me, Mr. Chair.
Please.
15-minute time warning.
Okay, I got about 2 more minutes, and I'll just say the recommendations that came from the group, the task force, was not on getting rid of preponderance of evidence, but adding more procedure, specifically making it clear that you can't base preponderance of evidence just on a police record, and that you need more corroboration, and the individual would get an opportunity to be heard prior to the determination. And it doesn't say you get a hearing, but it says you get to be heard. And so, yeah, that's one of the problems is even if you win, it might have taken 9 months to a year. The job's gone, and you're left with sort of a hollow victory. So I'm going to conclude with that. And the goal, again, is just to try to get you some information about the 2007-2008 group and see what, as use it as a starting point for subcommittees and discussions here. Okay, I'll stop with that. Thank you, Mr. Vogel, for your reminder. And why don't we move on to a discussion about the subcommittee discussions. Maybe I'm gonna defer on the first one since I've been talking, seems like, for far too long. To the remedies, we're going to go out of line a little bit. Maybe we'll do the remedies subcommittee. Ms. Dawson, are you online and available?
Yes, I'm happy to start.
Okay, thank you. Thank you.
Yeah, no problem. Give you a chance to kind of rest your voice there. All right, so my name is Lucas Dawson. I am the chair of the remedies subcommittee. So it's just kind of a little bit of just some brief overview for everyone who has not been part of those meetings. So we have met twice so far. We met on December 21st and again on January 10th. And we are currently scheduled to meet every 2 weeks through February. So kind of just some updates on what we have looked at so far is we definitely started with the original list that I think was presented to the whole task force back in December. And so at our first meeting, we identified various topics that the group wanted to research and discuss further. So just kind of some broad overview. One of the topics was the permanent bar that's currently under the statute, and to look at really whether that permanent bar should exist. And if it should exist, is there some sort of a remedy that should actually be available to people who do have a permanent bar? We also wanted to look at the efficiency of the process. So whether it's really user-friendly, understandable, kind of what Chair Griffin just touched on. This is a process where somebody is not entitled to an attorney, and we are looking at statutes and an appeal process that has quite a few consequences for people who are involved in it. So again, whether it's really user-friendly, the length of time that people have are the current lengths of time really appropriate? For example, for a 30-day, can someone really gather all of the necessary documents and turn all of that around to provide it to DHS? One topic that was brought up is, for example, if people are all within the same agency, but then they're moving around, and whether there really are traveling set-asides and how that can work, and if it's causing delays. And then, of course, also really who should be allowed to work during this process, both during the actual background study itself, as well as the appeal process. Another topic we're looking at is the preponderance of the evidence standard, the POE standard. Should it exist? Should there be something else, some other sort of process? Another topic that came up are expungements, and really making sure the expungement statute works with the disqualification statute. We also wanted to look at the administrative accountability. So part of what we're looking at is hearing from DHS as to how they make their decisions, who makes the decisions, what type of discretion is used by the individuals at the Department of Human Services. So really to understand, I think we all kind of feel in order to really tackle this, it's helpful to really understand the nuts and bolts from DHS's side of things. Another piece that was discussed was also any changes that are made, the retroactivity of the statute. So as part of that, we ended asking for some research to compare our statutes to other states, to really sort of see what other states are doing, as well as looking for a presentation from DHS, again, to really learn more about their process, because it directly impacts what we're looking at. So then the next meeting on January 10th, Mr. Vogel did present an initial presentation. He has started compiling some of the disqualification statutes. And I think that presented us with some other interesting pieces to look at. So for example, we did learn through his research that a majority of states require a conviction for there to be a disqualification standard, or a disqualification, that it does not appear there's actually a preponderance of the evidence standard in other states. It simply requires a conviction. Some states do not actually have permanent disqualifications. And then states that do, there are others who actually do have a reconsideration process for disqualification. So I think an interesting point. And then just a need to streamline that decision-making process, kind of what I had touched on from that prior meeting. So at our next meeting, if I remember correctly, I believe we are planning to hear from DHS. We were also going to take a look at these recommendations. So that presentation was very helpful today, Chair Griffin, just because we are going to be looking at that specifically, of course, the discussion about the permanent bars and the POE portion of all of this, as well as Mr. Vogel was doing some additional research to give us a little bit more information about what other states have as far as their statutes, to again look at what are other states doing, what seems to work, what doesn't seem to work, especially as we're looking at what sort of recommendations we want to make here. So if there are any questions? I'm definitely happy to answer any questions that anybody may have. And hearing none, thank you. Oh,
Well,
wait, there was a hand raised, Vice Chair Evans.
I just wanted to, if I remember right, Ms. Dawson, the preponderance of the evidence, because this was a little shocking to me. Is it true that when somebody asks for it to be reconsidered, the preponderance of evidence, and they lose, you only can do that one time, right? And then you never can appeal it again. It's done.
That is my understanding. Once you've lost that that process, that is then that disqualification, and you are left with whatever that disqualification period may be. So if it's a permanent disqualification, you have a permanent disqualification. If it's a 7-year, whatever it might be. But yes.
Mm-hmm. Thank you.
Ms. Dawson, I had a couple thoughts and questions. I mean, one of the things I would say too about preponderance of evidence is that could even happen when you're a juvenile.
Correct.
So you could get a permanent disqualification on a non-conviction as a juvenile, and if you don't appeal it again as a juvenile, it's over. One of the things I appreciated learning more that you guys are looking at permanency, because I think the disqualification subcommittee was looking at that a little bit too. So I'm glad that we can let go of that. So we'll defer to your subcommittee on that. One other thing I always found frustrating with the department on, it's mostly for set-asides, is that the forms aren't available online, and you can't submit them online. So you have to either fax them in or mail them in. And yeah, fax. I saw Representative Mueller like, yeah, so yeah, you can, if you have a time machine and go back to 1992, you can fax it to DHS. So I wonder if that's something that might be brought in there too. It just isn't. And actually the 2007, 2008 group sort of focused on DHS's lack of data helping people. And I think things have gotten a lot better, but I'm hoping that can continue to get better.
And I can just add, we are planning to look at that set aside in the variance process, because I think that definitely goes back to the initial sort of big overarching as whether it really is an efficient process. And is it really up to date, if you will.
Does anybody have anything else for Ms. Dawson and the remedies subcommittee?
And if I could just note, because you had brought up the juvenile piece, I think if I remember correctly, is the because I know that's a very important piece, at least for me, and I think some other people. If I remember correctly, is the disqualification subcommittee looking at that piece? Because if not, I would definitely want to make sure we're looking at it too.
You know, we're looking at the juvenile piece, but I think there's definitely going to be some overlap. And maybe the next time we report, we can focus on what we're looking at with the juvenile piece. I mean, we're looking at juvenile disqualifications, but we're not really looking at, okay, if you are disqualified as juvenile, what remedies are available to you? So I think there'll be some overlap. So I can hone that down in our next subcommittee meeting and tell you where our review of juvenile disqualifications stops.
Well, and I think one important piece for us is whether we're going to look at, is it a conviction only? Because that would automatically exclude many juveniles, because those are adjudications. So I think that's an interesting piece for us to look at as well. And I'll make a note of that.
Okay. I saw that Judge Kulik had do you have some contribution, Judge? I want to make sure we
yeah, on the remedy issue, I understood that even if you asked to have your disqualification revisited, if there's no change and the agency determines, yep, you're disqualified, we got it right, that you could appeal to district court, which of course is a whole nother thing, because there's another bureaucracy that's hard to navigate for the layperson. But I'm just wondering if I'm wrong about that you can't appeal to district court.
There is, I do know, and I can touch briefly, there is a process where you can appeal to the district court, and I apologize off the top of my head whether, depending on if you actually qualify for the fair hearing process, if that's when you can appeal to the district court, which of course is also a cumbersome process. And at least the last time I looked, I don't think there's any actual forms available. So it's definitely a little bit of sort of compiling some forms that you're hoping will work and then getting them filed, and fingers crossed.
So yeah, if you get the fair hearing, if you have a fair hearing right, you can appeal your fair hearing result to district court. But if you request a set aside, there is no right to an administrative hearing. So if the department denies your request for set aside on reconsideration, your next step is actually the Court of Appeals. So people who are denied a set aside actually never get to talk to somebody. It's all in writing. It's all paper, which leads has always been my concern that that's a pretty inequitable thing, because really it becomes a writing contest. Can you say those magic words? Can you write well enough to get, and you can't tailor your argument to cross-examination. And then you're at the Court of Appeals, and there's so few cases. And the truth is it's abuse of discretion on review, and they're really hard cases to win.
As far as the right form, wouldn't that be an easy fix through the law libraries? Because a pro se self-represented person can go to any courthouse now, and many of them are staffed with a licensed attorney. Even Mille Lacs County's is, who can guide you to the right forms. And people are doing their own divorces and their own evictions. They're doing their own probates. And I would think just adding those forms to the law library forms that are available online for every other matter would be a pretty easy fix.
And I think the issue is just, the court forms available on the Minnesota Judicial Branch website, and I was just attempting to pull it up now. But I don't know that forms have necessarily actually been created, which I know is at least a problem. I mean, at least as an attorney, I can generally understand how to create a court form. But of course, if you're a non-represented litigant, that's much more difficult. So I think there could be an easy fix, absolutely, but it would require, I think, the creation of some forms, which, I'm not entirely sure how forms get created that can put on the judicial branch's website. So that's maybe something a bit more, but something to look into.
It'd be nice to have them on DHS's website too, because
Yes.
that's where people are going. I mean, it's interesting. They're very rarely appealed, and when I've appealed them, I've often gotten calls and people from the judges, clerks, and what the heck is this? Why do we have this? And you're like, tells us where to go.
So John, there's a few folks that have their hand up, and I'm just going to start with my personal experience with the process. I was denied and appealed it and went to the courts and hired an attorney that I thought knew what they were doing for $500, and found out once we did all of that and went to the courts that the thing that I had, which was involuntary termination of parental rights for my kids, was a permanent disqualification, and so lost anyways. And I consider myself fairly educated and thumbed through the bureaucracy and all of that stuff, and it still was wrong. And so looking at other folks who may have some other struggles, right? And so I don't know that the bureaucracy, some people may be able to file for their own stuff, but not everybody's in that position. And so I don't know, I feel like we're creating more disparities by, that's one way to solve it maybe, but not for everyone. So I know, but Senator Champion's got his hand up, and so does Kulani. I would love to hear from DHS.
And my question was around the road that you just traveled, Vice Chair, around costs for an attorney, and what's the filing fee cost?
So at least I do know it's whatever the standard court filing fee. And of course, if someone cannot afford it, which is usually, I think it's somewhere a little over 300, between 300 to 400 dollars. And so, of course, if someone cannot afford it, they can apply for a fee waiver, which I think the self-help centers are very good at they are good at helping people with the fee waivers, and they do know about those. So that process, I do think, is covered, at least from what I understand to be covered. But of course, there is a filing fee, and if somebody cannot afford it, they would have to apply for a fee waiver.
It just appears and feels like we should give a different thought process around this. Even if there's a process of informal papyrus and you can do all those other things, think about the time and attention that you have to give to this when some of these things should be dealt with in a much more fluid way. And then for us to really think about someone who's doing this based on a POE where they were never, charged even with a crime. So it just seems to me that I think that we have to think about it as a comprehensive approach as opposed to just a siloed approach. So that's all I was going to say. Thank you.
And Kulani, Madi, I had noticed you'd had your hand raised, but you've taken it down. So I wasn't sure if you wanted to add more.
Well, the one thing I was going to say, this is, I'm Kalani Moti with DHS, is we appreciate the conversations and what everyone's raising and how you all are working through it, because we see a lot of that. I just wanted to share about set-asides. I would say that a lot of set-asides are reviewed in an appeals hearing in front of the HSJ. So you do have the right to, for most set-asides, to be able to appeal that decision if it's not set aside and go through that process and do that. And the agency would have to defend their actions on that. So I want to do it. It's not for everything, but having seen that process, I just wanted to clarify that on that point as well. So that was the only thing I was going to mention.
Thank you.
And Will had informed me that we're past 15. I think if it's okay, we go a few more minutes. I see Mr. Esme's hands up, and I know we'd like to hear from him. So if everybody's okay, we're just going to go a couple more minutes because I think this is an important discussion.
Yeah, I'll be really quick. I just wanted to react briefly to Ms. Moti's comment. I think that's really helpful. Thank you for clarifying that. And one thing that even as a practitioner in this area has always confused me and I just sort of didn't really understand is why those appeal rights seem to be different based on, the different types of jobs or the different types of specific licensing provisions that require the background study. So I think maybe something that we should look at is seeing if we can smooth that out and just have that be the same process for everybody, or at least understand why it might be different for one type of job for another.
Thank you.
Well, thank you, Ms. Dawson, for leading that discussion and for all of your work on the remedies subcommittee. I know she wasn't here when we started, but I think Ms. Williamson is here now. Ms. Williamson, are you on and available?
Good morning.
Good morning.
Chair.
Nice to see you.
Hi.
Are you can you lead our discussion on all the hard work you've done on the data subcommittee?
Yes. So with the data, I just very honored to be a part of that work and the support of DHS to get those requests fulfilled. So at this point, we understood from the initial task force meeting, we did verbalize a list of requested data. And so one of the first meetings of the subcommittee, we learned quickly that verbalized list was not the appropriate way of requesting the data, that it needed to be formalized in a written request and then submitted. And so, therefore, we were able to do so. In the data committee, we all kind of worked together with a working document to make sure those requests went according to what had been asked in the larger meeting. We were then told we were given an anticipated date to receive that first data set. And unfortunately, there was a network issue and then personnel issues with DHS where they weren't able to provide the information at the time they had initially stated. I am happy to report that we have received one of the data sets. It's a total of 3 requests that have been made to date. And so we do currently have one of those data sets, where the committee, we are the subcommittee where we yet are planning to do a deeper dive into the set that we've received. So on our next meeting, which is, I believe, next Monday at 8 a.m., we plan to take that deeper dive on the set that we've received so that we can then just do a summary. And then we're planning on the larger task force meeting in February to hopefully have all 3 data sets, to have also asked our initial questions in regards to the data sets, as well as formalize any additional requests that may come up as we're delving into the information gathered. And the hope is that we can continue to have DHS at our meetings just to help streamline with the questions that we have, because we don't know what we don't know. So really looking to them to give support in that regard. And then the hope is that come our full task force meeting in February, that we can have a member of the data team at DHS to be in and to be present as DHS can prepare to do a presentation, a summary of the data that we've received. So yeah, we're just trying to make sure that we are asking the correct questions to gather the data that we need. A lot of our questions initially was based off of the aftermath, if you will, where the 3rd data set that we've recently requested was in regards to the process. We're also looking in regards to data regarding like the accountability fees, in addition to just making sure that it does have the disaggregated features to what we are requesting.
Ms. Williamson,
Mhm.
I apologize for interrupting, but I do see that Representative Mulder's hand is up and I wanted to give her that opportunity.
Oh, yes, please.
I can wait till she's done. It's fine. I can wait till she's done. No problem.
Sounds good.
So, but no, thank you, because I did not see your hand, so I appreciate Chair Griffin for letting me know. So yes, more so, we just want to make sure that, because with the data, that is really going to give a clear picture of, we know with what's apparent, we know with, those of us who have personally had instances, but having the data to really just show that evidence, if you will, of the numbers is very important to the recommendation drafting that we're preparing to do as a task force. And Mr. Vogel, if there's anything you want to add to my overview, please feel free to add that as well.
Actually, if you don't mind, Ms. Williamson, as I recall, the next data subcommittee is actually going to be next Tuesday at 8 a.m. due to the Martin Luther King Jr. holiday. These holidays sort of throw us all off.
Thank you for that. And so initially for this month, we have been meeting weekly, and that's strategic in regards to preparation for the start of the 2022 regular session. And of course, we're also trying to make sure we have what we need in regards to the draft that we are preparing to have prepared for March of this year. And so please ask your question.
Yeah, thank you so much. And I think that the work you're doing is really, really important, and the data is going to be very important in the report. And as a legislator, we really do want to see that information. And I'm happy to be joining your subcommittee because I am really interested in this issue. I missed the last large group meeting, and so I apologize if this was asked and answered in that meeting, but I thought that this task force had funding for DHS to hire somebody help with these data requests. And I'm wondering, first of all, whatever happened with that. And then second, I know Ms. Williamson, you mentioned wanting to present this data to the large group in February. And I just want to make sure that we can hear from DHS that we can actually get this data so that we can have that information available to the large group in February. And so whether you can answer that or someone from DHS, I think it would be really helpful to know the answer to those two questions. Thanks.
Yes, I would actually defer to DHS. I know the answer for the first question, of course, but I would defer to DHS to please answer both of your questions at this time.
Hey, good morning. This is Chris Semple with DHS. So the first question regarding the funding for the position, we did post the position earlier this fall, back in September, had it open for the required amount of time, and unfortunately did not receive a robust enough candidate pool from which to hire from. I think there's a few challenges. One, it was a short temporary position. It's only temporary funding. And so even in the best of times, those can be challenging to fill. And then two, in the midst of the workforce shortage, I think that just exacerbated that challenge. So we would love to have filled the position, and we're working to get it reposted, hopefully to help us work towards that second and final report. But that's currently in progress. Right now, we've asked other members of our team just to fill in for the work that position would be doing, including myself. So our hope was to have that person be the lead point staff person with the task force, and we're all pitching in to make this happen. To your second question, Representative, so we've provided the first data set to the subcommittee. The second data set, we are hoping to be ready by the end of next week, and provide that to the subcommittee. And then the third data set 2 weeks after that. And so a lot of this data, and we've been very transparent about this, we don't have a data clearinghouse in our system. So there isn't a place where our system is automatically updating a database of any sort. So we have to manually go in and pull data out of our living background study system, and then sift through it, make it intelligible and consumable, and then make sure it doesn't violate anybody's privacy rights. And so it is a very labor-intensive process, hence why it takes time between such a long period of time between each data set. I believe that was both of your questions, correct, Representative? Okay.
I had a quick question, Mr. Semple. When will this job be reposted?
It is currently in queue with our HR team. And so there are a lot of pressures to hire. Again, with the workforce shortage, we are having challenges across the agency filling positions. I can check in with HR and let the task force know when we expect that to be posted.
Yeah, I think it'd be important for us to have some updates on that as it goes on, whether it's posted, whether because last I remember hearing was it was not at the top of the department's lists for filling, so it wasn't moving forward. And then this was sort of new information, and I'm just trying to figure out. It'd be nice to know more as the process is ongoing.
Like every other part of the department, Mr. Chair, we try to prioritize our positions with HR. And so they take each part. And so this is a position that we have put priority on for our part of the department, but HR too is under a staffing shortage as well. And they're trying to churn through all of that work at the same time. And so I will follow up and see where that's at in the queue, and see if we can't speed up that process.
Thank you. I appreciate it.
Mr. Chair, I also wanted to stay in with my presentation. I'm sure you can all see my background. My children have went back to distance learning. So Just wanted to say that piece. That's the apology. And I do, again, I just want to just share that we appreciate the support and just want to make sure that we can continue to have support from DHS at all of our meetings. In addition to, and we're making sure to be duteous of providing that written documentation so that we have that paper trail, but that we can continue to have the support. We even asked DHS to please let us know. Again, we don't know what we don't know. So if there's processes or certain type of data that we haven't requested that they know is available. I know with COVID that there was a lot of data that was gathered, especially disaggregated data, that they would please let us know, make those suggestions to us in what we're trying to do here. Thank you, Chair.
Thank you, Ms. Williamson. Does anybody have anything to add or comments about the work of the data subcommittee before we move on? Okay. I don't see anybody's hand up. If I missed it, please let me know. And we look also very, very much forward to the dissemination of some of that data. I think it's important for us to understand everything from the data side. And we'll move on now, and I'm going to do a short presentation on the work of the disqualification subcommittee. We have met on 2 occasions. We'll be meeting again next Tuesday. So some of what we've been doing is just sort of getting our heads wrapped around disqualifications. Some of the issues that we've been discussing is the fact that an individual cannot obtain a background study unless they're offered a job or volunteer, or I guess technically through a school. So you really can't find out if you're disqualified prior to kind of entering the field. And anecdotally, I've had a lot of clients over the years who are pursuing a career of some kind that requires a background check or background study, I should say, and they become aware of a disqualification midway through their studies, late into their studies, and are unable to work in an area that they have studied. I get calls too from individuals that just say, hey, do you think I'm disqualified? And it's somewhat easy when you look at criminal records, but as we've talked about, I think at length, the preponderance of evidence standard can really mess things up, because you can say, well, you don't have any convictions that would disqualify you, but the department may look into this issue and you just don't know. So then people say, well, I need to know before I pursue this type of job or quit this job to do that job. We also get a lot of calls from attorneys who are defense attorneys who want to settle a case and say, if I settle this case for this nurse this way, will they be disqualified? And based on the conviction, they won't. But the preponderance of evidence standard can be problematic in that as well. So one of the things we've talked about is there a way maybe that individuals can have a background study initiated without a job? That's one of the things we've talked about. One of the things we're looking at, I think, seriously is the list of disqualifying convictions and making determinations whether or not we think there's some nexus between the actual conviction and safety. We're also looking at the length of that disqualification period. If an individual has a conviction or there's a preponderance of evidence conclusion, how long should that person be disqualified? Does the statutory scheme make sense both for safety of vulnerable individuals and for people who want to work in those areas? We were looking at permanency, and I think it's fair to say we'll probably step back from the permanency review now that the remedies group is looking at that. I think we weren't looking at the set aside component, but we were looking at whether it should exist, and if it does exist, what offenses should be on there. We're looking at juvenile matters. We're looking at how juvenile records can be used to disqualify individuals and whether or not that makes sense. Juvenile records are not criminal convictions unless the individual is certified as an adult. These are adjudications. The juvenile court system is designed as more of a rehabilitative process, and under current law, an adjudication of delinquency is essentially the same thing as a conviction, and whether or not that makes sense in the grand scheme of things. And then I think what we're anticipating we'll do next is, once we sort of have this long list of things we're looking at, we're going to decide priority. We're going to look at which ones of these cause us the most concern, and then start coming up with solutions and possible solutions for those issues that cause us concern. So I think by next week, we've sort of asked the subcommittee participants to look at the disqualification laws and come up with ones that they find unfair, disturbing, and be prepared to explain why. And then we'll move really towards that ranking, similar to what we did as a group as a whole when we first sort of talked. And I don't think the ranking would be something that we would have to stay with, but at least getting an idea what causes us the most concern and how to use our limited time and energies towards rectifying some of those problems. And I would certainly want to include anybody on the subcommittee, the disqualification subcommittee, to add anything, because certainly there's things I'm sure I missed. So if there's anything anyone wants to add, or if anybody has some questions, we're certainly willing to discuss those, and we'll continue to update the full task force moving forward. Okay, so I think we're moving forward with our subcommittees, and I appreciate everybody's time and effort on those. I think it's a wonderful way to move forward. I think it's really kind of helping us a lot. One of the things we know about this area is we can study it and we can look at the law, but we need to continue to hear the voices of people who have been impacted. And one of the regular things we want to do is just hear from people. We're going to have a discussion now from an impacted individual and hear their story and how the disqualification laws have affected them. And then we're going to have a discussion about how we best move forward to incorporate a broader group of individuals who are impacted by these laws, and to find ways to listen and to make this process something they can weigh in on. Vice Chair Evans, have we decided? I know we've had some changes with who would present today.
Yep. So Tashonda said she is willing if Duan said he wasn't feeling good. So I will. Duan, are you still feeling under the weather and just were listening today? Is he still on?
Buttons here. Sorry. I'm just pushing the buttons here. Yeah, my voice is like horrible right now. Like, so
okay.
Like,
nope.
I don't really have it right now. Yeah.
Yep. Nope. Next time. So Tashonda, if you are interested,
Yes, I would be happy to do so. My apologies. I was getting my chai tea. Let me just
Thanks,
grab that.
Tashonda.
You're welcome. Here, just give me one moment, everyone. Thank you. Okay. Thank you. Can you all hear me? Yes. Okay. So I had there was an unfortunate circumstance that my family had been through, where my sister was dealing with some mental health issue, concerns. And so in regards to getting some support, I became kinship provider for her two children, her two daughters. And just as things was going on, this was about 2 years, and as things was going on, the support seemed to be as one where I was in need to adopt the children. And there was this is my half sister, and there was some issues from, we have the same mother and different fathers, and where father had sent a slanderous letter regarding me because the older of the two had a little scratch on her eye and I knew that night before because I would cut their nails, and they were getting long, and she just cut her cheek just a little bit. And when I had brought them for a visit, they submitted a letter saying that she had said that I had did it. Well, she couldn't even talk at the time, so but that prompted an investigation. And with that investigation, the investigator, just because of what they had been through, my nieces, especially the older one, she had trust issues as far as new people being around. And we were having like the guardian ad litem therapy. I had some physical therapy persons that were coming in my home weekly, sometimes daily. And so with her, a lot of trust issues when new people would come around. So of course, with this investigator, she was definitely there's some things she had experienced, and so the investigator just took to that there was something wrong with this child and looked to me to be to blame, not realizing these children were in my home because of what they had experienced. And then come to look, and I had been licensed, had went through, did the background, had done the whole process. And then my oldest daughter, back when this was like 5 years prior or 6 years prior in high school, she had mentioned about me. She was upset because of teenagers, and was saying that I had hit her. And I'm thinking a counselor had come to the house, and I said, it is my right as a parent to discipline my children because I don't want them to grow up as ministers of society. I want them to have moral values. And the counselor, who I thought was saying, completely agree, that is well within your right to do. Just so you know, I agree with you with what you're saying. And from what I understood, the end of it. Well, here, 6 years later, they look and see that was actually a child protection investigation, that there was no case that came of it. But said that I was informing, which I thought it was a counselor from my school. I've never had any issues with child protection or anything to that extent. But then use that to then immediately come and pull my nieces from my home, just because there was an investigation, even though there wasn't even a case open from the current investigation, there was no case that came from it. But because there was an investigation, with me being kinship, they came and removed them immediately, and to put a disqualification on my name for 10 years off of something that, first off, I didn't even know that that's who that person was. There was nothing that came from it. I've never been arrested, never anything. And just thankfully, and then all paperwork being thrown at me, I had no idea like what all this was, what it meant, nothing. And just happened to see the South, I get the name mixed up all the time, but the Southwest Metro Regional, I know who I'm talking about, sorry, I apologize. Happened to see that, and I'm just like desperate, like I don't even know what to do here. And as I said, I had been keeping them for the prior 2 years. I was going to school for nursing at St. Catherine's, and they required so much attention because of what they had experienced. And so financially, not able to up and get a lawyer. And so I called the number and went through, I talked to 3 different people, and they all were saying, we don't really take these types of cases. Usually when you go with the department, they always win, but we'll take it, we'll go through the process. I'm like, I don't really know what else to do, and I ended up getting a lawyer, where I went in and told them my story, and they thankfully, thank God, they said, you know what, we don't normally take these types of cases, but we'll take yours. But I want to let you know, most likely you might not get the verdict that you're hoping for, but we'll represent you. And I had my day in court. We went forth, and I did win my case. Everything was rescinded. You pull up my name, that still shows up. Could I have expunged that to have that clear? No, I wanted to do that because I wanted to show. You have people here. I was the one that had called child protection in regards to my sister getting the support she needed, and me being able to do for my nieces, because there was a time in my life where I could, with my own children, and just really made huge sacrifices for them children. And like I told when I was on the stand, I told that appellate judge that I said if I had to do it all over again, despite everything, I said I wasn't gonna cry. Despite everything that I've been through, if I had to do it all over again, I would, because I'd rather I've suffered than have to live with regret, knowing that something had happened to one of them and I hadn't done anything. That would have just, so I'd rather have suffered what I had went through than had not done anything. But the very system that I was hoping to help my family and support and give resources was the very system that was not what happened. And I just want to just fast forward and say, with my attorneys going forward, there was no type of legal remedy that could happen because the department, I'm not saying all this as being someone that's revengeful or spiteful or bitter, none of that, because there's so many wonderful things that have come because of my experience, right? I want to be an advocate. I want to help so that the Department of Human Services and any other department that is here to serve the constituents, the community, can do exactly that. They're getting funding to be of service to the community and to understand the rigidities of their accountability to the participant, but also understand what they're doing and have accountability and infrastructure assessment to make sure they're doing right by the community. And just my last little part in this is just to say, I was appointed with the CECLC, the Cultural Ethnic Communities Leadership Council, and was even elected as the Madam Chair. Well, here I'm trying to work countless hours, working internally, trying to work internally with DHS to remove disparities, which is what that council was appointed to do. And let me tell you, with the bureaucracy with that council, it's just, that's a whole nother topic, but very bad experience I've even had with that. There needs to be accountability, compassionate accountability. And my last point here is that administrations have adjudication. The adjudication is meant to just clarify the laws and the statutes for the constituents. However, adjudication has the interpretation of it seems to be off because it seems to have been used, and the data shows that, the disparities show it. It seems to have been used for departments to act as the enforcer, the lawmaker, the enforcer, and the judge, and not allowing people the opportunity to be innocent until proven guilty. Hearsay, giving people permanent disqualifications or tenure or whatever it is, and you don't even have the evidence. Again, mine was just off of a slanderous letter. and all of us that came from it. I can just imagine how many people there are that didn't have the opportunity that I had of being represented. We need to do this for humanity's sake. There's already institutional racism that is perpetuating all this, and then we have systems that, again, antiquated systems again yet perpetuating the marginalizations and disparities among communities, especially of color, minority communities. This needs to end for humanity.
Thanks, Desanda.
Yes, I agree. Thank you so much, Deshonda, for sharing your story. I appreciate your willingness to talk about things that are difficult to talk about. I think it's important that we hear it. So our last item today on the agenda is to have a discussion about the best way to bring people in and hear some voices, whether it be in writing or whether it be listening sessions. Some of the things we had sort of talked about, but this was very preliminary. We're disseminating just even a link where somebody could write and post their story. They could do it anonymously. They could have their contact information included, whatever they chose. Whether that link would go directly to our the Legislative Task Force website, but just something that could be created that way. Another idea that we came up with was just having some listening sessions where we create a Zoom platform, disseminate the date and time to impacted individuals, and we just listen. It would be taped and hearing stories. Certainly the whole task force wouldn't need to be there, but some people, anyone who chose to be, could be. And then we could find a way to communicate those stories to other people. But I think it's important that we hear those stories, because even though we have a lot of experience with it, we haven't lived it, and hearing from people that lived it is important. So with that, we just sort of thought it would be great to hear from everybody's brilliant mind that's in the task force on what might be a good way to make sure we're listening and listening to people who aren't on the task force. Yes, please, Mr. Esme.
Well, I like the idea of a listening session. I think I think we had talked about trying to have a sort of voice of impacted people be a consistent presence at our main meetings. And I think we should still do that in some way, but I think we're going to have enough to do at our main meetings that putting aside a separate time and place to really focus on gathering those perspectives, I think makes a ton of sense. So I would vote for that. I would just, a couple ideas I had while you were throwing that out there. One, I'd like to see us really make an effort to reach out to not just individual job applicants who have been disqualified, but also the folks that are trying to hire people and are not able to hire people and not able to fill positions, and the impact that that's having on all of the businesses and our healthcare institutions and all of those things. And secondly, I like the idea of allowing people to submit a written comment, but I wonder if it might make sense also to open that up to allow people to maybe leave a voicemail or like a video of themselves sharing the story. I think that might make it even more accessible to folks.
Great ideas, Mr. Esme. In terms of the employer perspective, I think it's an important discussion too. During the disqualification subcommittee, we had Mr. I think it's Irwin from Adult and Teen Challenge talking about connecting with an applicant for a job, knowing their history, knowing their story, and wanting to hire them, but with the disqualification being prohibited from hiring them. And what a unique kind of issue that is, that even an employer who gets to know somebody is prohibited from hiring them. Like at Target, if they want to hire somebody from, who has a I don't know, an assault one from 25 years ago, they can do it. But in Minnesota, in these direct care positions, the employer would be prohibited. It's actually, I believe, a misdemeanor to hire them. So I think it's a good thing to remember. So I thank you so much, Mr. Esme. Ms. Kaser?
Thank you, Chair Geffen. And I really appreciate the idea of, a write-in or a video, and also maybe kind of dually doing some listening sessions for those who maybe just want to come and share their story at a certain date and time, don't want to access or put something out on the internet, or don't have time to do that. One thing I just want to note is making sure they're also keeping broad in the scope, that it's not just about employment. Certainly my focus and passions around, this is impacting child foster care, adoptions, child care licensing too, which has major impacts across, and there's huge needs there. So I know that's the background studies impact a lot of different areas, even beyond what my passion is too. So I just think we have to think about how we word that, that we want to keep it at anybody's stories and how they've been impacted by background studies.
I appreciate you, Ms. Kaser, raising that issue again. I know that you and Mr. Luck have brought it up before, and I think it's something, sadly, you might have to continue to remind us, but we are 100% on board, because it is a broad area. And I agree. And with that, I did have a conversation with Joanna Woolman, who led some of the changes in this area, and she has agreed to come to our next task force meeting and present for 15 minutes on the changes in that area. So we're on board 100%, and I think sometimes our language doesn't show that enough, but we are. I agree, and I think we need to make it broad when we put out those requests for stories. And we'll certainly request your input to make sure that the language we use includes that. Thank you very much. Does anybody have an idea? I really like the idea of being able to leave a video or a voicemail. On the technology side, does anybody have, is that something that they've seen done before that we could replicate? Any ideas on? Because I think it's a great idea. I just have no clue how to do it. My 10-year-old son probably does, but I certainly don't.
I would look to Will, because I feel like we're locked into some of the open meeting and all of that stuff, to maybe look to the LCC, or to find out, are we locked into some rules or whatever about it? To not know, but to find out for us.
And Chair Geffen, Michelle Weber with the Legislative Coordinating Commission. We have had groups that have taken written testimony when individuals aren't able to participate in a group in one of the scheduled public meetings, and then we post that written testimony along with it. We don't have the capacity or experience collecting videos or posting videos. There are some accessibility requirements that we have to be cognizant of if we were to have video statements, that those videos would also be accessible, include things like closed captionings. And so logistically, it could be incredibly challenging for us to do that, but we certainly have had a great deal of experience offering for individuals to provide written testimony if they're not able to be available, and that written testimony then being published with the meeting.
Thank you so much, Ms. Weber. And maybe Mr. Vogel, that you and I and Vice Chair can have a discussion maybe after this to sort of figure that out and present to the next full meeting what we think is possible in terms of the technology side, and with the restrictions that Ms. Weber discussed, because I think we don't want to get bogged down and not get it done for a month and a half. And even if we can get something where we got listening sessions and the ability to do something in writing while we work on, if we choose to work on sort of Mr. Esme's idea of the video and video or voicemail. the other thing, and this goes with Mr. Esme's point too, is I think one of the goals we have is to do some of these very large meetings, listening sessions, but to continue to include and invite individuals who are impacted to our task force meeting, maybe having one 10-minute presentation to each large task force meeting from an impacted individual, maybe focusing on 1 week issues with adoption or other licensing issues, then the next week a preponderance of evidence, but to sort of give a rounded view so we hear some additional stories from people outside the task force. I think we'll work on that and try to present something for next session. Is that something, Mr. Vogel, you think that's appropriate and doable?
Certainly, Mr. Chair. I can set up that meeting right after this one, or
Okay.
not necessarily right after this one, but I'll set it up after.
Got it. Understood. I think that, Mr. Vogel, please correct me if I'm wrong, sort of concludes our business for the day.
Yes, Mr. Chair, that's everything that's on the agenda.
I will open it up, though, if anybody has anything that isn't listed on the agenda that needs to be discussed. Is there anything?
Yes, I'm
Hi,
wondering,
Judge.
as I think about juveniles and the adjudications being different, and the fact that back in the 90s, we legislatively created the extended jurisdiction for juveniles because there's a whole body of knowledge and data about the juvenile brain and brain development and the lack of culpability, which is why we don't try really little kids as adults. And I just wonder if there's any point to, maybe for the disqualification subcommittee, getting somebody in who can just give a summary overview of why that is. I really feel strongly that we need to address the juvenile issue because these are not just, you can go 20 years and never commit another crime, like the young man that I was telling you about. But also these are, crimes committed at a point when these kids have no impulse control. They don't have any understanding of consequences. They are not fully formed human beings yet. And we're, in some cases, giving them a lifetime disqualification for things. So,
Judge, do you think the person to bring in would be like focusing on the science of adolescent brain, or are you thinking something else along the lines of just the juvenile process, court process?
Oh, wow. Well, those are both good things for everyone to understand because right now we have different processes. And I think you made the point today, our juvenile system is all about rehabilitation, unless you've got this disqualifier, then you can't be rehabilitated for some purposes, even if you were 11, 12, 13 when you did what you did. So both, people need to understand how the juvenile system is different and also need to understand why it's different, which is the whole brain development culpability thing for juveniles.
I think it's a great point, Judge. And I think we're going to start working on finding those individuals, and with your permission, we'll be reaching out to you to get your thoughts on whether or not we're selecting the right folks. Okay, thank you so much, Mr. Esme.
Yeah, I think that's a great suggestion, and I was just going to throw out a name. Professor Perry Moriarty at the University of Minnesota Law School has a lot of expertise on this issue and has presented at various legislative hearings and the Sentencing Guidelines Commission and stuff like that. So one person locally who I'm sure would be more than willing to help us with that issue.
Another name is the retired Professor Barry Feld from University of Minnesota. And he, I think, is one of the authors of the EJJ way back in the 90s. He was a huge help to me with my first certification study when I had a juvenile in front of me with a serious crime.
I know Perry very well. I'll reach out to both of them and see their availability. I'm excited. Those are, I think, perfect names. Thank you, guys.
I just, Chair, I just wonder if there are any other topics like this juvenile brain development thing that anybody on the task force would like to hear about as we're looking to future task force meetings.
You know, one of the issues I was thinking about, and Josh Esme might have some thoughts on this too, is having Emily Baxter and who is, I believe, the executive director of We Are All Criminals. I don't know if people have read her work before. That just really talk about, if we're being honest, maybe a lot of us have made mistakes, and some of us just didn't get caught. And you know. I think a lot of us who are, again, being honest, realize that that's probably true. And that when you create a system of laws that just punish people, not really based on who they are, but maybe some other, you know, just getting caught isn't a great idea. And that we have a lot of people that are really successful and are doing great things in the world that have some criminal history. Mr. Esme, you think that? I mean, are you on the board still at?
I'm not on the We're All Criminals board, but I certainly could reach out to Ms. Baxter. I'm sure she'd be interested.
I think we should look at that, because I think it every time I hear her speak, it reminds me of how maybe we're all pretty much the same. So, if you wouldn't mind, Mr.
I would be happy to, and I agree it's a good idea. I think it highlights a point that I think is worth considering, that I guess the inputs into this system aren't consistent amongst, you know, every parts of our community. And so, yeah, I think it really is another aspect of this we should be thinking about.
Okay, thank you, Mr. Esme. Based on Ms. Vice Chair Evans's comments, does anybody have anything else they would like the large group to discuss, or the subcommittees to look into regarding disqualifications? Ms. Kaser, please.
Thank you, Chair Griffin. This is not probably a fully formed thought, so it just popped into my head, but I did wonder about maybe something around the intersectionality between chemical or substance use and criminality in some way. Again, I'm not really sure where to go with that, but knowing, again, increased rise epidemic with opioids and such, is how are we looking at that and thinking about that with changes to background studies?
Yeah, that would be good. Maybe the Minnesota Sentencing Guidelines Commission or Kelly Mitchell could do something around that.
Ms. Evans, you want to have a conversation with Ms. Kaser, maybe kind of offline, to kind of figure out how to get that idea baked a little bit more, and how we incorporate it, because I think it's a good idea. Thank you, Ms. Kaser. And if anyone else wants to be a part of that, I know Mr. Kammerer might have some interest in that and knowledge in that area. So I want to include anybody. Certainly reach out to Vice Chair Evans if you have interest in being a part of that. Yes, Ms. Robertus.
I just wanted to share too, you know, the state has ORAC, the Opioid Advisory Committee too, that if you wanted to double up or combine forces on suggestions, whether like legislative or financial, I just wanted to throw that out there, that they're working hard too. And I believe workforce expandment is a part of some of those elements.
Okay, yeah, I think that's fantastic.
Yep, I would also say Ms. Robertus also has a lot of information about intersectionality between substance use disorder and I don't know that I would say criminality, but the outcome of criminality. They've got some data that they put together every year at the Department of Corrections that I actually use quite a bit when I present. So they have, Jolene's got some good information. So
Well, certainly let's incorporate that data too. I mean, I think we talk about data and we think about DHS, but I mean, I think there's data that DOC might have. There's data. I think we need to look at data as a pretty wide net or a wide array. So let's bring that in. And, you know, when we talk about criminality, you know, I think everything, devil's in the details. What's our definition of criminality? So I'm excited to learn more about that. Yes, Representative Moeller.
Thanks. One thing I've just sort of been thinking about during the meeting today are victims of domestic violence, both when it comes with respect to, you know, if we were to eliminate preponderance of evidence standard and understanding how those cases work. And sometimes there isn't enough evidence because of recanting victims, but then also on the flip side, wondering if victims are also subject to disqualifications that might need to be considered. And I don't know if anybody here could speak to that, or if it'd be worth having someone from like Violence Free Minnesota come at some point to talk about domestic violence issues specifically, you know, on both sides of whether it's for the perpetrator or the victim. I just don't want to forget their voices. And correct me if I'm wrong, I don't think we have someone from a victim organization on this task force. I was looking back at the membership.
I'm unaware of certainly if somebody feels that defines their employment or their role, please speak up. I think it's a good point. We don't, and we haven't had a lot of discussion about victims at all.
We could have Nikki from Violence Free Minnesota come talk.
Vice Chair Evans, is that something that you could connect with and see when that individual is available? Okay. I'm not seeing any more hands, but last call. If you got something to say, say it now. Otherwise, I think we'll be done. We had scheduled 2 hours, but I think our goal was to try to be closer to an hour and a half. Can see everybody's got the Zoom face on and looks a little tired. So I'm with you. It's a fatiguing process. And I think with that, Mr. Vogel, is there anything else that we need to discuss today before adjourning?
I don't believe so, Mr. Chair.
Thank you so much, Mr. Vogel. So we are at this point adjourned. Thank you all for your participation and hard work. It's fantastic. Bye, everyone.
Thanks, everybody. Have a good weekend.
Thanks.